I'm Sadhika, student of Dr.B.R.Ambedkar College of Law, Andhra University. In this video, we are going to discuss about the essential elements of a contract. What is a contract? According to Section 2, Clause H of the Indian Contract Act 1872, contract is an agreement which is enforceable by law. So, contract is equal to agreement plus enforceability. Contract is something more than an agreement. Therefore, it is said that all contracts are agreements, but all agreements are not contracts. According to Section 10 of the Indian Contract Act 1872, all agreements are contracts if they are made by the free consent of the parties competent to contract for a lawful consideration and with a lawful object, and are not hereby expressly declared to be void. In other words, when two or more competent parties freely consented to enter into an agreement not declared void with a lawful object for a lawful consideration, the contract is said to be a valid contract under Section 10 of the Indian Contract Act 1872. To constitute a contract, the following conditions are to be satisfied. Two parties: offer, Section 2 Clause A, and acceptance, Section 2 Clause B. Consensus ad idem, identity of minds. Capacity to contract, Section 11. Free consent, Section 14. Lawful consideration, Section 2 Clause D. Legal relationship. Lawful object, Section 23. Terms must be certain. And finally, possibility of performance. Two parties: offerer, Section 2 Clause A, and acceptor, Section 2 Clause B. To constitute a contract, there must be an offer and acceptance. The person who offers or makes an offer is called offerer, and the person or party who accepts the offer is called acceptor. Therefore, in every contract, there must be at least two parties, namely the offerer and acceptor. The offerer and acceptor must be communicated properly to each other. Consensus ad idem. Consensus ad idem is a Latin term that simply means identity of minds. A contract to be valid, there must exist consensus ad idem. It means identity of minds between the parties to the contract. In other words, both the parties to the contract must have agreed about the subject in the same sense and at the same time. In the absence of the consensus ad idem between the parties, the contract is declared null and void. Example: A has two horses, namely X and Y. A offers to sell X to B. B accepts thinking that it is Y. Here, there is no identity of minds and hence it is not enforceable. The parties to the contract must be competent to enter into a contract. That means they should have the capacity to enter into a contract. According to Section 11 of the Indian Contract Act, any person is competent to contract provided he is a major, not a minor, he is of sound mind, not of unsound mind, he is not disqualified by law and forced to contract. Free consent. Consent means giving willingness or assent. According to Section 13 of the Indian Contract Act, two or more parties are said to consent when they agree upon the same thing in the same sense and at the same time. Consent is said to be free when it is not caused by flaws in consent. Section 14 of the Act defines free consent as: consent is said to be free when it is not caused by coercion, undue influence, fraud, misrepresentation, and mistake. Lawful consideration. Consideration is one of the most essential elements for the formation of a contract. It means something in written. It is a price for the contract which refers to both the parties. A contract to be valid and enforceable, there must be a lawful consideration. Example: A sells his house to B for Rs 10 lakhs. Here, A's lawful consideration is Rs 10 lakhs. Similarly, B's lawful consideration is the house. Therefore, it is said that a contract without consideration is void. That means a contract without consideration is not valid and enforceable. It has been contained in the Latin maxim that ex nudo facto non oritur actio, which means out of a nude fact, no cause of action arises. In other words, a contract without consideration is void. However, love and affection, compensation to the voluntary services, and time-paid debts are the exceptions to the general rule under Section 25 of the Act. Legal relationship. A contract to be valid, it must create legal relationship between the parties. Mere domestic or social agreements do not give rise to create any legal relationship. For instance, a lawfully wedded wife cannot sue her husband for pocket money or other things outside the legal necessity. The relevant leading case law on this point is Balfour vs. Balfour. The defendant in the instant case was a civil servant in Ceylon. When he left for England, he promised his wife to send £30 per month, but he did not send the amount. The plaintiff filed a suit against her husband. It was held that the suit is not actionable on the grounds that it does not give rise to legal consequences. Lawful object. A contract to be valid, the object for which it has been entered into must be lawful. According to Section 23 of the Indian Contract Act 1872, an agreement entered into with lawful consideration or object is declared void if it is forbidden by law, defeats any provisions of law, fraudulent, causing injury to person or property of another, or immoral or opposed to public policy. An agreement which is harmful to public welfare is said to be opposed to public policy. Such agreements are agreements in restraint of trade, agreements in restraint of marriage, agreements in restraint of legal proceedings, wagering agreements, agreements to commit a crime, agreements with aliens. Terms must be certain. The terms and conditions of the contract shall be clearly mentioned in the agreement without any ambiguity or vagueness. In other words, the terms of the contract must be clear and certain. Otherwise, the contract is not valid and enforceable. Example: A offers B to supply 100 tons of oil. In this example, the terms of offer are not clear, since the nature of oil, that is, whether it is coconut oil or groundnut oil or etc., is not mentioned. Relevant leading case law on this point is Toiler vs. Portington. The plaintiff in the instant case promised to take defendant's house on lease for a period of 3 years, provided it is thoroughly repaid and the drawing rooms are decorated according to the present style. It was held to be not enforceable since the terms are too vague and uncertain. One of the essential elements of a contract is possibility of performance. If performance of a contract is impossible, it is void. In other words, impossibility of performance renders the contract void. Thus, Section 56 of the Indian Contract Act lays down that an agreement to do an act impossible itself is void. Example: a contract to construct a building in 2 days. Since it is impossible to construct a building in 2 days, the contract is void. So these are the essential elements of a valid contract. We will be discussing about each element in detail in the coming videos. Thank you.